Hey there, this is Eric Perrott from Gerben Law Firm, and I find that my clients are always surprised about the different types of things that can be protected under trademark law. And I found a filing that I thought was interesting and shows the depths of that protection and maybe also the limits of that protection, especially when it comes to protecting the shape of a product. And this is a filing from a little company out of California that you may have heard of. And if you guessed that this is the Apple Airpods, you would be correct. And it was filed on April 25th, 2019. And in it, Apple is claiming exclusive rights in the configuration shown here. And in general, the shape of a product is something that can be protected under trademark law, but only if when consumers see it, they only think of one source, or in this case, Apple. Apple is essentially saying that the buds as they appear in that case, as shown in this drawing, is something that is only associated with Apple. Now there are some limits to that protection. It can't be functional, meaning that it can't be a configuration that would give Apple a functional advantage over competitors of a way of holding, charging, or displaying the earbuds. That's for patent law, that's not for trademark law, and can't be registered with the Patent and Trademark Office or protected under trademark law if it's functional. And it's this last part that Apple's dealing with. About a week ago, the examining attorney who was assigned to this application denied it on the grounds that it is merely functional and is not something that can be registered. Now, Apple's goal in making this filing is likely to stop the flood of copycats that are in the marketplace, like these $25 so-called Apple Airpod knockoffs. And you'll see that they're in the exact configuration that this filing is trying to protect. And the question is, can they own something like this? And I think that the answer is it's tough. It's maybe. They'll need to show that the shape of these AirPods are not functional and that by having exclusive rights in this, they wouldn't gain any functional advantage over their competitors. And this can be difficult to show. If Apple does have a patent on any of these parts, then that might be evidence that this is functional and that the way that this operates is all things that Apple considers to be a part of the usefulness of this device. Now, how does this apply to you or your business? I think that a lot of, especially with Amazon and some of these online marketplaces, there's some really creative product packaging that's involved that often attracts lookalikes and competitors and knockoffs. And you may not even realize that that's something that you can protect. So you might be leaving rights on the table by not protecting them. And you should consider assessing all of your company's trademarks. So that could be logos, that could be different color combinations, it could be product packaging, all the different things that could be protected, and really looking into each one of those to see if you can maximize the benefits. On the other end of that, if you are creating a new product, it's important to know where you are being inspired by another company and where you might be violating some kind of trademark rights or other kinds of rights. So this stuff is important to understand, and it can be difficult to sometimes comprehend. So if you ever have any questions, feel free to reach out to me and I'm happy to discuss. Thanks.